Community policing forums and business anti-crime groups have banded together in the wake of the unrest in KZN and Gauteng. They're preventing any further looting or damage to property in their areas. While this has been largely welcomed by residents, concerns have been raised about the lawfulness of such groups. To talk more about CPFs and what they can and cannot do, I'm joined by policing and public security specialist David Bruce. Can you tell us about the ability of CPFs, the legality of actions, what they're allowed to do in situations like these?
Okay, well, I don't really see this as specifically a conversation about CPFs. CPFs are a structure that's provided for in terms of the Police Act, and they're supposed to be established at each police station, but they don't have any powers that distinguish them in any way from any other civilian formation in situations of this kind. So CPFs might be one of the formations or types of groups that mobilized in the situation, but I think there would have been quite a variety of different ways in which community responses were organized.
So we saw how stretched the police resources were. Many organizations, like you've said, CPFs and other community groupings got involved. Unfortunately, we did see some vigilante activity as well. But for those involved, the lines might be quite blurred. Clarify that for us, if you will.
Well, you see, I mean, I think that is exactly the point, that in some ways the lines are blurred. But the basic principle is that people do have the right to defend themselves. I think what President Ramaphosa was sort of giving his endorsement to last night was people who took peaceful measures to defend themselves. And, insofar as it was possible or for people to use non-violent measures to protect themselves, that would clearly have been preferable. However, in terms of the principles of the law, people are entitled to defend themselves. They are entitled to use reasonable force to defend themselves, including their property. The major qualification to that is that they are not allowed to use lethal force unless there are imminent threats to their lives or the lives of other people.
Very clearly to the point of bearing arms. Many of these organizations, community groupings and CPFs were heavily armed. They were using, in some cases, rubber bullets, but in some cases using live ammunition. What does the law say about the parameters of what they are and are not allowed to do?
Well, we get into, again, some areas of ambiguity. What is clearly regulated by law, is the use of firearms and possession of firearms with live ammunition. Beyond that, as far as I understand, there isn't a clear regulatory framework regarding, for instance, the use of the possession of weapons which rely on the use of rubber bullets, or at least the use of rubber bullets by civilians. And so what one needs, again, it links into these principles about that people are allowed to use reasonable force to protect themselves. They need to, but insofar as they are using lethal force, that is only justified or legitimate against a threat to their lives or the lives of other people. And so, insofar as people were using, firearms, particularly firearms with live rounds, they were in situations where there were not imminent or direct threats to life, they were potentially involved in transgressions of the law.
What does the law or the regulatory framework say about roadblocks manned by CPF groups or community groups, and whether they can legally conduct search and seizure operations or make citizens' arrests?
Okay, so again, I think, these were extraordinary circumstances. My understanding is that if people had a reasonable belief that people are not usually authorized to, restrict access to their communities, but in situations where they had a reasonable belief that there was a serious threat of violence to their community, including members of their community and property within their community, it could arguably be seen as a reasonable measure to defend themselves. And so, as far as I understand, it would, in this situation, there would be a reasonable argument that they were justified in doing this in terms of principles of self-defense. I think once they gave, but obviously what is seriously problematic, the one thing would be is insofar as people were applying discriminatory principles in terms of who they were admitting to the community and not admitting to the community. So I think what one would like to have seen from people in that type of position is that they apply some other type of objective basis for assessing whether people should be admitted or not, rather than purely doing so on the basis of race. In terms of, searching and seizure, well, as far as I know, the law doesn't explicitly authorize that. So, potentially on a technical legal basis, one might be, they might have violated the law. In terms of whether it was something that was reasonable for people to do in extraordinary circumstances is another argument or discussion that we could have.
Absolutely. We're going to have to see how the legality of that impacts on possible prosecutions for crimes being prosecuted as a result of this looting. But thank you very much for your insights. We do appreciate your time. Policing and Public Security Specialist David Bruce.